Sacramento Metropolitan Cable Commission is now in session for March 18th, 1994. And with that, to establish a quorum, I'll ask the clerk if she'll call a roll.
Pratt.
Here.
Castanis.
Here.
Collin. Panay.
Here.
Dickinson.
Here. Who did you call?
Dickinson.
Dickinson. Well, he's not here.
We'll put on the record that Toby Johnson is here.
I didn't have my hearing aid on, so I fouled it up. Okay, we do have a quorum.
Wait a minute.
We have another quorumette coming in here now.
We have a few more names. Yee.
Here.
Collin.
Here. I know he's
That did it.
Purcell sitting in
Here.
for Cox.
Oh, now we finally
We
got
have a
it all.
quorum.
Good. Good roll calling. With that, we'll let all the audience know that this meeting of the Sacramento Metropolitan Cable Television Commission is being videotaped in its entirety. It will be broadcast again without interruption on Metro Cable 14, the Government Affairs channel on the Sacramento Cable System. The meeting today is being cablecast live, and it will be repeated Saturday at noon, not at night. This is a great day. I'm glad you're about ready to take over.
You're probably giddy just for that reason.
Hey, I'm so excited.
You're so excited that...
And among other things, anyone wishing a VHS copy may obtain one by checking it out from any branch of the Sacramento County Library System. And the members of the audience wishing to address the Commission should fill out a speaker identification form, which is located on the back table at the back of the room, and give it to the secretary, the young lady to my left, Diane. Please speak into the microphone when addressing the Commission and state your name for the purposes of the record. And with that, we'll get on to the business of the day. Before we do, I'd like everyone to know Harriet Steiner, the lady seated with...
Hi.
This lady will be advising us on legal matters, and we're very pleased that you're here. And we do a lot of illegal things, so you'll have a lot of work to do.
Well, I'm very pleased to be here, and I know you do nothing that's illegal.
And with that, Mr. Panay is to be our chairman for the forthcoming 95-96 year, but he's going to quit halfway through the year in order to accommodate his few remaining months, his family. Yeah. Oh, you're quitting to accommodate your family. We're letting you take the chair officially today to accommodate you.
Oh, I see.
But we're pleased that you are thinking of your family first and above all else. And with that, I don't think there's any need for any more discussion. Mr. Panay, this is the gavel. You pound it when you want order or when you want to hit someone over the head. And,
all right.
With that, we'll move the chairman's sign over to you.
Okay.
And you're officially chair. And there's John Hirschberger, and he's turning in the first slip that you're going to have for him to speak.
Okay. We have the first item, if the clerk would like to read.
We have Sacramento Cable Television transfer of ownership.
Mr. Esposito.
Mr. Chairman, members, good afternoon. This item was the original purpose for calling this special meeting. It's triggered by a March 17th notice from Sacramento Cable Television of its intent to transfer ownership of the system. At your last meeting, you asked to have a report back from your counsel on this issue, and I'd like to turn it over now to Harriet to bring you up to speed on where we are.
Ms. Steiner.
You have a report in front of you from me. It analyzes the change of ownership provisions in the franchise ordinance, and it finds that, in our opinion, the proposed merger triggers a rebuttable presumption that there has been a change of ownership based on the definitions in the ordinance. And I can go into that in greater detail if you like. In our opinion, having triggered the change of ownership, it's up to the Commission to determine whether there actually is a change of ownership, and if so, to schedule a public hearing to discuss that and get input from the public and make your findings with respect to whether to approve a change of ownership or not. The board can, if it wants, put the issue of whether the rebuttable presumption of a change of ownership exists also on at the same time as the public hearing. I don't think you need to make that decision today in order to schedule your public hearing. I understand from the representative of Scripps that they may want to ask for a delay in the public hearing. based on some concerns that they have, and you may want to hear from them as to whether or not you want to maintain an April 7th hearing date.
Okay. Any questions from the Commission? Mr. Costanis.
Yes, Ms. Steiner, regarding the Commission's authority, if we were to not allow the transfer, what are the ramifications of that?
If you were to not allow the transfer, it would have to be based on the factors in your ordinance, and the franchisees would have the ability to sue you to determine whether or not your denial of the change of ownership was appropriate.
Would that necessarily cause a lawsuit, or?
It could potentially cause a lawsuit.
What other options do they have?
They cannot go forward with the merger.
So we could actually prevent them from going ahead with the merger.
Arguably, you could do that.
Mr. Yee.
Yeah, Mr. Steiner, the questions I have is that assuming that the new owner has sufficient financial backing, and assuming they would accept all the obligations and responsibilities of the current franchisee holder, are there other things that this commission should be concerned about?
Well, your ordinance provides that in the event of a change of ownership, in addition to making sure they have all of the things that you just enumerated, you have the ability to determine whether they're in full compliance with the terms and conditions of the franchise. So it's also an opportunity for the Commission that if there are areas where they believe that the franchisee is not in compliance or not in full compliance with the franchise terms, to discuss that with the franchisee and the proposed new owners, and to come to terms as to how those matters would be remedied.
So we will find this out during the public hearing from people in the public?
People in the public, and I assume that Mr. Spasto would also have a report for you on that issue.
Yeah, that would be the other comment. Mr. Spasto would take a look and make sure that they conform to all of our conditions.
That's correct.
Okay.
Ms. Collins.
My questions would relate to any request to continue this beyond the April 7th date. My understanding was from the time that they serve notice, we have a time clock running and that we have to make some decisions. And I'm just wondering what the effect of trying to go beyond that date is and what our options are if that request is made of us.
I think you do have time clocks that are running, and I think if they were to make that request of you, they should also give an extension of time at least as long as the extension beyond the 7th, so that you're still in at least the same position that you would be had you held the meeting on the 7th. The other alternative to them is to withdraw their notice of intent to merge, and with the understanding that they would have to file a new notice at a later date, which would kick in new timelines. But I think that at the very least they would have to make up that time within your time deadlines.
You know, because I would think it would be extremely important that, you know, that they do some of those things if they're going to make that request, and that we have that in some sort of really formal writing, because if we don't, we'd have to notice this hearing pretty quickly. To have a hearing on April 7th, we would not want to lose our opportunity to properly notice a meeting. The other concern I would have is if there are outstanding issues left between them and between us, we would want to make sure that we have adequate time to get all those in the public record and they have a chance to cure it all too. So those would be the concerns I'd have.
Okay. Any other questions from any other commissioners? All right, we have one member of the public who would like to speak. Penny Costa.
Good afternoon. I am a member of the public, but I'm also the attorney for Sacramento Cable Television with respect to this particular matter. As an initial comment, I'd just like to say, though, Harriet and I did have a conversation yesterday about the possibility of requesting a continuance of the hearing date from the 7th. Following our conversation, I did go back and we have reevaluated the situation and determined that there really is no need to ask you to continue that hearing date. So the date that has been recommended by Ms. Steiner fits within the time frame we think for making a determination of whether in fact there will be a merger or there won't be. So as far as whether the hearing date should be moved to a later date, we don't feel the necessity to ask for that relief. We're perfectly satisfied to accept the April 7th hearing date that is under recommendation.
Any questions from the Commission? Just one question. So you're saying it may not be the intent to merge?
Let me tell you what the situation is at this point. Whether there will be a merger or not has not yet been determined. The parties are discussing the prospect of a merger and negotiating the terms of it, but there has been no agreement at this point to carry through with a merger. We notified you of the prospect of the merger because we felt an obligation to let you know that it was under consideration. There has been no decision by anybody at this time, between the two parties as to whether a merger will in fact occur. That will be the result of discussions and negotiations and agreements to terms if it in fact occurs.
So you anticipate prior to our April 7th date that you would know that?
Yes. If it becomes clear that there will not be a merger, we will certainly let you know as soon as we know, and certainly no later than April 6th, that we don't anticipate that the merger will go through. And failing that, we intend to be here on the 7th and to respond to your questions and to put forth our case.
So if you haven't made a decision, you're saying...
We will be here.
You will be here,
yes,
speaking as if you are going to merge.
Yes.
Mm-hmm.
We are committed to the April 7th date unless we notify you on the 6th that there will be no need for the meeting.
Okay. Any questions from the Commission? All right. Thank you. You might notice in your memorandum the year was off 1 year. So
I would like to make some comments, if you all don't mind, about
Sure.
the question that's before the board today, and that is whether whether this merger would contemplate a change of control, as that's defined by the ordinance. It's our position, as set forth in the letter that you received, that there would not be a change of control, and let me explain to you why we feel that that's the case.
Excuse me for one moment. Let me just get some clarification to make sure that this is proper, that we can speak of this issue specifically without notifying the public of it. Ms. Steiner, could you give us your view of this? It seems that this goes into the issue of the merger itself. And it seems to me that if we're going to get involved in the issue of the merger, then the public should be notified of that case, that we are going to discuss the merger itself.
Better argue it then.
Excuse me. And then it's better to argue, make your arguments in front of us in that public sense, I would think would be the most appropriate public forum for that.
The ordinance, as I read it, raises a rebuttable presumption that a transfer of control has occurred, and only in the event that the Commission determines that a change of control has occurred is it my understanding that there is a necessity for a public hearing where the Commission would determine whether to give its consent or to withhold it. So my intent today was to present our position in response to Ms. Steiner's recommendation that a presumption has been raised. I would like to make comments to suggest to you that we don't believe that the Commission should determine in fact that a change of control is proposed. Therefore, if that were your conclusion, there would be no need for the hearing on the 7th and no need for the Commission to actually issue consent. Consent is only contingent upon a determination by the Commission that the proposed merger would result in a change of control, as that's defined by the ordinance.
So the long and the short of what you just said is what?
The long and short of it would be that your counsel has recommended, it's her recommendation that she believes there would be a change of control, and I would like to address that and have an opportunity to convince you otherwise. If I'm successful, there would be no need for a public hearing on the 7th and no need for a vote by the Commission as to whether or not it should give its consent. If the Commission determines that I have rebutted the presumption, there is no change of control posed by the merger, then there's no need for consent to the merger.
Yeah, we have before us two recommendations at this meeting. That's what I understood. One of the recommendations was to say that it is a transfer of control, and therefore we're going to set the April 7th meeting. And so I would think that if she wants to argue that it isn't, certainly we've been presented evidence that it is. And so
I would think we should
probably hear her.
Retain the hearing date of April 7th and have it at that time so that public members who had
That's true, but we have to make the threshold issue of that there has been, that it does constitute a transfer under our ordinance. My understanding was we should do that today so that we can set the hearing on the 7th. If that's the recommendation before us.
Why don't we have Ms. Steiner give us her view of this?
I think the board has two choices before them, and you may want to decide which way you want to go. The description of the ordinance given by Ms. Costa, I think, is accurate. The proposed transfer raises a rebuttable presumption that there is a change of control. It seemed to us that there was sufficient evidence to maintain that presumption. The board has two decisions to make before it, either one of which you could make today or you could make on the 7th, and the other one you would need to set a public hearing for. The first issue is, is there the potential for a change of ownership or a change of control? If you were to find today that there was not, then you would never set a public hearing because there was no change of control or change of ownership. If you want to listen to evidence on that today, you could. If you want to say that there has been a rebuttable presumption based on what you see in front of you, and you can decide, you can set the public hearing, and on April 7th you can determine, yes, there is, or that presumption exists, or it has been adequately rebutted by the franchisee, and you can hold the public hearing right then and there on whether or not you should approve the change of control if you find that there is.
No, members, my preference, since we don't even know that this operator is going to be merging, as we've heard from their legal counsel, my preference would be to hold the public hearing on the 7th, as Ms. Steiner has stated in her last portion of her statement, and decide that threshold question then. It may very well be that we don't waste any time because there may not be a merger, I'm told. And if there is no merger, then we haven't wasted the Commission's time, we haven't wasted your time. That would be my preference. Move it to the 7th. Decide that threshold question. If there's no merger, there's no threshold question to decide.
But that would be the same as adopting the two recommendations before us. And it would be that we do
set the hearing.
Well, the other one is you've got to have the finding, and then.
No, I don't think so. I think that what Josh is suggesting really is a punt on the first. Yeah. That's the first
my suggestion. I know what the memo says, and I think you're correct in that. What I'm saying is the board has the ability, if they want, to set the public hearing and determine today that that the merger in and of itself establishes the rebuttable presumption, and you'll decide on the 7th whether that presumption has been or can be rebutted or has been rebutted. And if it is not, you'll go forward with the hearing, and if it is, or if there is no merger, then that would be the end of the issue.
If we have the discussion today, though, and on whether whether I'm able to rebut the presumption, then there may not be a need for the hearing on the 7th.
But it's possible, ma'am, just to put it bluntly, that members of the public would like to come in and give their testimony on this issue as well. But in the case that your company does not merge, I would say that we'd be saving a lot of everybody's time right now. So it's up to the Commission if there's a motion.
I agree with Josh entirely that people may want to present some information to us, and if we foreclose that opportunity, even though it may not be, as you decided or described it, necessary to go forward with this, I'd like to hear if any of the public have any concerns at all about this whole matter.
Any other commissioners have anything? Mr. Costanis?
From what I understand of the issue, I think we'd probably be prudent on everyone's time if we were to wait until the 7th. It seems to me that instead of going through this exercise now, knowing full well that there might not be a merger coming from the company. If that's the case, then this is time that we don't need to spend.
Yeah.
Well, then I would like to move the recommendation of the attorney that uses the language establishes the rebuttable presumption, and then schedule the public hearing at the April 7th date.
Second.
There's been a motion by Colin, second by Mr. Toby Johnson. And I just want to point out something. The date was in Ms. Steiner's memo, not your memo, so
94.
I appreciate that.
94.
So I'm sure that'll be corrected.
I'm sorry, we'll get with it with the right year.
Yeah.
Fairly.
I still look at 93 and say, are we at 93?
Sorry.
Any questions? Yes, Mr. Purcell.
Just one question of counsel. Does the foreknowledge of our presumption that there's a change of ownership here have any effect, you think, on the actual decision that they're going to make about whether they do merge or not? Are we putting ourselves in any kind of position with the Securities Exchange Commission or anything like that?
I think all the commission is doing is following what your ordinance says. I couldn't speak to whether or not that might have any effect on their proposed merger.
Thank you.
Any other question? No other question on this item. Madam Clerk, please call the roll.
Pratt.
Aye.
Costanis.
Aye.
Collin.
Yes.
Yee.
Aye.
Toby Johnson.
Yes.
Dickinson.
Aye.
Purcell.
Aye.
Panay.
Aye.
Motion carries.
Okay, the motion
Can I
carries.
just clarify something for Rich and I? The motion, as I understand it, is that you found that there is a rebuttable, that if the proposed merger has raised a rebuttable presumption of a change of control, you've scheduled discussion of that issue, whether they can rebut that presumption for the 7th. You've also scheduled for the 7th a hearing on the change of ownership in the event that the board finds that there has been a change of control.
Yes.
So we would publish that as the notice. for the
Exactly.
Yes, that would be it, and I would hope that before that time, that if there are under our ordinance impediments to the transfer, that those be prepared under if they are in violation of any of the ordinance or regulations, that be prepared. So that the franchisee has that information at the time, sometime before that hearing. So if they want to get that cleared up, they can. They'll be aware, and the public will be aware of what issues might be out there. And I would assume that can be done.
Okay. I'd also just like to remind the commission that at the hearing, when if you discuss the change, if you find that there is the presumption and that there will be a hearing on the change of ownership, that it's up to the franchisees to prove by clear and convincing evidence all of the factors that are listed in the ordinance, which I believe you have in front of you.
Good. And I do, Mr. Chairman, if I may.
Yes.
Presume that you'll bifurcate the issue for the agenda on
Yes,
the
sir.
7th as well, just
That's
so
what we
that's
just
very
clarified
clear.
now. We
Okay.
bifurcate the issue.
Okay.
As I see now, we have a noticed item relative to the rebuttable presumption, and if that's a go, then we have a noticed public hearing on the transfer.
Right. Okay.
Stan, thank you.
Thank you very much.
Thank you.
Okay, Madam Clerk, item 2.
Cable Commission fund balance.
Mr. Espasto.
Mr. Chairman, members, at our commission meeting on the 3rd of this month, you directed staff to seek guidance from each of your parental jurisdictions on what to do or recommendations on your fund balance available. So in the last week, staff has met with each of the jurisdictions or contacted each of the jurisdictions. I'd like to report back these findings. The
And
cities.
you're absolutely right, Mr. Espasto. They are parents, too.
Yes.
We found that out in these deliberations.
Yes. These are our parental jurisdictions, or your parental jurisdictions. The cities of Folsom and Galt recommended that you distribute the funds in accordance with your existing policies. The city of Sacramento, after a lengthy discussion, recommends about an hour and 40 minutes worth. Recommended that you hold the funds in an escrow account, which essentially would be a appropriated reserve in administrative terms, until 1996. That having two ties to it. One, 1996 would be the end of the current litigation settlement payments by Sacramento Cable Television and the time at which Sacramento Cable Television's payment of fees to you reverts to whatever is happening on a national basis pursuant to the requirements for franchise fees. Presumably by then we would know if franchise fees still exist in the national structure. The Board of Supervisors, meeting with 3 members, took no action and opted to wait and see what the recommendations were from the other jurisdictions.
The Board of Supervisors?
Oh, that's nice.
The Board of Supervisors made the motion to tell the Cable Commission not to spend the money.
Well, that's okay.
That was
too.
the only thing 3 of us could agree on, because 3 people went 3 different ways, and we didn't have the wisdom of Mr. Dickinson there, and Muriel was gone. So I would, I would suggest, after hearing that report, that what this board do is follow. It would be my motion that we go along with that recommendation from the City of Sacramento, which is keep the money in an account at the Cable Commission and wait for the 1996 date.
Second.
The 3 of us from city seconds it.
3 from the city seconded. Okay.
We have public testimony on this item. If
length.
you'd like to make the motion, it's been seconded.
At least they know it's on the floor.
Right.
We will keep this in an escrow account at the Cable Commission and not spend it until we'll look see what 1996 brings.
Let's hear from members of the public. Mr. John Hirschberger first.
They're going to come up and testify and change our mind. You're in great danger.
Hello, I'm John Hirschberger. I'm President and General Manager of KVIE, and with me today is Liz Rhodes, Executive Director of Sacramento Educational Cable Consortium. And clearly, we would like to see the funds that are in question here committed to uses that benefit cable subscribers, specifically community and educational programming. And yet we have to bow to the wisdom of your parents and recognize the prudence of a compromise which would direct the Commission to hold on to the funds until we know what happens with the franchise fee issue in 1996. And I think along with that, some language which would guarantee that bits and pieces of that wouldn't be siphoned off somehow between now and 1996. And for that reason, I think we would support Ida Collins' motion.
Thank you.
And I am here for Dave Vacca and Dr. Jay Thompson. Dave and both of them had planned on being here today. They send their apologies. Jay is down in Cupertino with Apple trying to raise some money for SECC. And Dave Vacca had an emergency at the district that he had to attend to. But both of them indicated to me that they wanted to make sure that you understood SECC does support the action of City Council and Ida Collins' motion, and also wants to thank you for your interest and your continued support of community programming, and also to urge you to keep in mind the intent of the whole idea of cable here in Sacramento, especially that of community programming. And the idea of cable even being here was that the community would make use of the resources that cable could bring to it. And SECC is very committed to that, as we think we have shown in the past, and we are very interested in continuing working with other grantees, including KVIE, and moving ahead in a strong direction to improve the services that have already been provided. So we do thank you, and we do support the motion.
Thank you.
All right, thank you. Mr. Ron Cooper.
I didn't quite understand what they were saying out there, joking.
Because of the way we monitor income.
I have a handout here today. I'm Ron Cooper, Executive Director of Access Sacramento, and also speak in support of the discussion that happened at the City Council and of Ida Collins' motion today, but also want to expand the discussion just a little bit with the handout that I'm passing around. This commission has, over the years, fought a very difficult battle in watching this tree called cable in Sacramento, nurturing it, helping it to grow, fighting off the beetles, And your staff has been very diligent in adhering to the ordinance, as witnessed today. This commission has also recently discussed where is the future going, where is Sacramento City and County, Folsom and Galt in this process. And I just wanted to bring for your information today that the reason why these community programming entities have been working so hard on your behalf and on behalf of your constituents is that we're really on the threshold of an exciting world here. And you read about it in the paper every day in every single section. And I brought forward to your attention today because it just brought it home so wonderfully today. This is multi-channel news. This is the weekly journal of the cable industry. And 3 articles in there just really jumped out at me. And I thought I'd share them with you. Reed Hunt of the FCC suggesting that utilities may have a role in this electronic superhighway. So the question before us, I think not in the too distant future, is one, again, for those who have been around a while, where does SMUD fit into this? I mean, the players are just going to be popping up here, there, and everywhere. In another article in the same magazine, Cable Consumer Group ring up FCC on dial tone. And very specifically, why I brought this to your attention, to quote, the cable industry and a prominent consumer group recently sent a message to the FCC, promulgate video dial tone rules fast because the telcos are on their way. The letter said action is critical because some of the country's biggest telephone companies are ready to plunge into cable, citing PacBell's plan to spend $16 billion over the next 15 years to offer video programming throughout the state of California. Public announcements by telephone companies indicate that these projects may be the tip of the iceberg. And then finally, feds earmarked $26 million for nonprofit highway use. At a press conference Monday, Commerce Secretary Ronald Brown said that the money would be made available for an array of nonprofit organizations with new ideas for connecting their establishments to larger networks for the purpose of collecting or transmitting information. According to the request for proposals, NTIA is looking into fund demonstration projects that empower citizens, promote equal opportunity, protect individuals' rights, and strengthen democratic institutions. The $26 million could be just the beginning, as the Clinton administration has requested $100 million in similar funding for fiscal 1995. Access Sacramento, working with other nonprofits, is applying for a piece of that $26 million. The community programming grantees have been planning for years in what we currently have been mandated to do and have done a wonderful job as we come in every month and report to you. But I think perhaps most exciting is where we stand now as a community because of all the work that all of us collectively have done over these years. We are poised as one of the leaders in the nation, and certainly in California, in the area of how this information is going to be, this information superhighway will be put to best use for our constituents and as a model for the rest of the nation. So I applaud your wisdom once again. Sometimes it takes a bit of doing to get there, but it seems as though we continue, and there are exciting days ahead. Appreciate your support. Thank you.
Well, thank you.
Thank you.
Is there any other person in the public who would like to come forward?
I'd like to ask Mr. Smith if his general recommendation has been changed.
No, but I thought the board spoke very well about it. I think Supervisor Collin expressed the action of the board, which was all 3 members did not object to holding the funds in reserve. Obviously, my recommendation due to the county budget cuts and cuts in human services that we will experience this year is that any surplus money from any constituent entity of the county be used to support basic human services. I think generally there's strong feeling to do that, but the board has already spoken, and I certainly don't want to speak against the Board of Supervisors, whom I enjoy working for.
It's so interesting.
Sometimes.
You heard 3 different people say 3 different things. The only thing we could agree on was send that back to the commission and just say, don't spend it.
Don't spend it. Good. That sounded familiar from the council point of view. Any other discussion on this item? Okay, there's been a motion and a second. Madam Clerk, please call the roll.
Pratt,
No.
Castanis,
Aye.
Collins,
Yes.
Yee,
Aye.
Toby Johnson,
Yes.
Dickinson,
Aye.
Purcell,
Aye.
Panay.
Aye.
Motion carries.
And the motion carries. Item 3.
Mr. Chairman, members, item 3 is the Executive Director Personnel Agreement. I have much interest in this, but I believe it appropriate for Mr. Smith and or Mr. Elam to present this item.
Okay. Mr. Elam?
You have before you a contract which complies with the motion that the Commission adopted on March 3, identifying specific terms. It's a contract that would hire Mr. Esposto for a term of 18 months commencing April 1 of 1994 and ending September 30, 1995. The contract would be terminable in advance of its expiration by 6 affirmative votes of the Commissioners, either for cause or without cause, but if without cause, the termination must be accompanied by payment of Mr. Esposto's salary, unearned salary, during the remainder of the unexpired term. The contract is automatically renewable for a period of 1 year through September 30, 1996. If by July 1, 1995, the Board does not give notice of its intent not to renew. However, in order for that renewal entitlement to be applicable, Mr. Esposto must place on the agenda for the Board of Directors by June 1, 1995, the question of whether his contract should be renewed. The City Manager and County Executive have negotiated the compensation elements of this agreement. They're embodied in paragraph 3, I believe. The document that you have before you is in error in one particular. It mistakenly omits a provision that would grant Mr. Esposto a $100 a month transportation allowance. That was agreed upon between the City Manager, County Executive, Mr. Esposto. I inadvertently left it out in the draft I prepared and sent to you. That provision has been added to the official document upon which you would vote today. There's one final provision in the agreement which was embodied in neither the Board's motion nor the recommendations of the two executives, and that is a provision requiring 90 days advance notice of a resignation by Mr. Esposto should the contract be terminated by him in advance of the expiration of its term. And that requirement is accompanied by a $200 per day liquidated damage clause payable to the Commission should the notice provision be violated. That is, should he resign without giving the 90 days notice. There would be a $200 to $100 per day penalty for each day short of that 90 days. The notice was not given. Contract is before you for adoption. If you have any questions, we'll be happy to answer them.
Any questions for Mr. Elam?
I have a question on
Mr. Castanis?
Mr. Elam, on the issue of the 90 days. Was this suggested by Mr. Esposto, or did it come from staff? Or?
Came from me.
And Mr. Esposto has agreed to that?
I have, sir.
And this $200.
And I tie it to reference last time the Commission met. There was real concern on the part, at least of Bob Smith, if not Commissioners, about what would happen if Mr. Esposto were to terminate his employment on March 3rd, how the Commission would be served. It's Bob's view, at least, that it would take about 90 days to find a new Executive Director. And so there is a real threat of damage to the Commission in the event that notice should not be given.
And a financial incentive for him to stay.
Yeah.
Or to give the notice anyway.
To give the 90 days.
Give adequate notice.
Any other questions of Mr. Elam? Mr. Yee?
Yeah, Mr. Elam, in this agreement, there's a termination clause with cause or without cause. And then there also goes on talking about 90-day notice if Mr. Esposto wishes to resign. Under those conditions, is there any requirement for payment or compensation?
No,
if he feels to resign, there is no requirement for compensation.
There is no payoff by the commission should Mr. Esposito resign. There would be a payoff only if the commission terminated without cause.
Got it.
Okay, any other questions?
If not, I'd move approval.
Mr. Toby Johnson moves, Ms. Collins seconds. If there's no further questions, call the roll, please.
Pratt?
Yes.
Castanis?
Aye.
Collins?
Yes.
Yee?
Aye.
Toby Johnson?
Yes.
Dickinson?
Aye.
Purcell?
Aye.
Panay?
Aye.
Motion carries.
Good.
Mr. Chairman, members, I'd like to say thank you to Mr. Smith, Mr. Edgar, and Mr. Elam for their assistance in the last 10 days. It's been very helpful.
Yes, thank you very much, gentlemen.
Thank you.
Appreciate the legal and administrative help. Thank you.
Mr. Chairman, before we adjourn, if I may, just to cover briefly what we will probably be addressing at your April 7th meeting. We have 6 items coming up on your agenda. Subject to confirmation from the chair, we're talking about the grand jury report and response, the 2 aspects of the SCT transfer, which we've just discussed, request a report back on affirmative action. I'll be bringing to you a staff report on legislative policy and an update at federal and state telecommunications legislation. I request an update on litigation. We're about to enter trial phases and litigation, and possibly, as I look at some of the actions we just made, a budget update and maybe a needed budget adjustment. So we have 6 items coming up for our April 7th meeting.
Any other items, any commissioners? No?
It doesn't look like it's going to be very short, Josh.
Yes, Mr. Yee.
Mr. President, I just want to let this commission and Mr. Esposito know that on April 7th, Mayor Cerna and I will be in China, so.
Where are you going to go? That's great, Jimmy. That's wonderful.
So if Rich, if you can contact my alternate.
Sir.
Thank you.
So you can all be assured that I'll be vetoing ordinances over at the City Hall.
You're going to have a wild time.
I asked the mayor if that was possible, and he said, no, I think you should check the city charter for that provision. But
you're going to have fun.
Only 5 votes, John.
It only takes 5 votes.
Oh, 5 votes. You might just want to consult Mike Kerb. Check on your authority.
Well, I checked the charter, and Mr. Castanis is right. It takes 4 other votes, and so I'll wait for those 4 votes to rally around me.
Right.
All right. If there are no items, do we have to have a public announcement for items not on the agenda that any public, I didn't see it.
This is a special meeting, so you're not permitted to take items off agenda.
I see. Sorry, public, if you're out there who wanted to speak, but okay. If there are no other business come before the commission, the meeting's adjourned.
Wonderful.